record button.
There you go.
Thank you. All right, everybody. Well, I want to thank you all for coming on out. We've got a big topic here. It's an important one that I think a lot of small businesses need to hear. A lot of updates going into place for 2023 here in Colorado. So we're excited to have the BBSI team on to kind of spin through this with us and kind of go through the changes that have been made. And we'll give Jared a chance to introduce who exactly BBSI is as well. My name's Dustin Nichols. I'm with Lakeside Insurance. I'm a commercial risk architect here. And then I've also got Jake Sharon in our office as well. He's a risk architect. And then I do want to just go over a couple rules before we get started. We're going to ask that everybody kind of remain on mute for the duration of it. If you have any questions, go ahead and throw it into the chat feature. I'm going to actually be filtering through those while Audrey's going through it. And, we'll stop periodically to kind of answer a few questions. I'm going to assume that there's going to be quite a few questions and we might not be able to get to them all. So if we don't get to your question, first of all, I apologize. We are trying to cram a lot of information here in an hour. But if we don't get to it, feel free to either shoot me an email, Jake an email, or Audrey's contact information will be available as well. And we'll get that on out to you. The other thing is at the very end, later today, maybe tomorrow, we'll be sending a follow-up email, which is a survey. If you don't mind filling it out, it's just going to be a quick 3 to 4 question survey that would help us out for future webinars that we're going to be putting on. So we'll go ahead and get started. Jared, I'm going to pass it over to you. And if you want to go ahead and introduce yourself and give a quick little spiel on who BBSI is.
Yeah, great. Thank you, Dustin. Jared Degenhardt. I am the business development manager here at BBSI, located in our Denver Tech Center branch. BBSI, we are what's called a PEO, a professional employment organization. And what that means, we partner with small and medium-sized businesses to help them in the functional areas of payroll, HR, risk and safety. We do business strategy, business consulting with our clients. We also offer a very unique workers' compensation product. Health benefits starting this year is something new that we're offering to our clients. And then also a new product we're just offering this year is recruiting. So we partner with businesses to help them run a more efficient business. We always say help our owners work on their business instead of in it. So by helping keep you up to date on these legal updates, or just make sure payroll's processed correctly, keeping your people safe at work. Those are the areas that we partner with, and we partner with Lakeside Insurance to help them help their clients do all of these things more efficiently. So that's kind of the 30,000-foot view of BBSI and how we work with businesses.
Appreciate it, Jared. Yeah, thank you for that. And we'll toss it over to Audrey to get us going, kick us off.
All right. So my name is Audrey Seavault. I have been an HR practitioner for now 39 years. It's still unbelievable, but true to me. I tell people it was right after disco got out of style that I became an HR person, and have worked in every role you could think of, from an entry level all the way to vice president of national operations for an HR company. Also, I'm an adjunct professor for the University of Denver, their strategic HR program. So the students are continuously teaching me more. And I want you to know, I'm putting a disclaimer here on this slide about, I'm not offering legal advice. However, I believe that, the business community should at least know the fundamentals of the laws so they don't have to call an attorney every time they have a question. I talk to the agencies a lot to better understand these laws. And in the state of Colorado, we have gotten a much more complex world of new laws and ever-changing laws that I'm going to walk you through. With that, I'll alert you to some documents that you need to pay attention to and provide employees. So I'm going to walk you through very quickly the cornucopia of laws that we have. We're going to go over wage and hour laws that have changed as of January 1st. You probably have heard of FAMLI, the Family Medical Leave Insurance Program that started this year with new taxes, next year with the leaves. We'll talk a little bit about the Colorado Secure Savings Program, which small businesses that are 5 or over need to pay attention to. We'll talk more about that. We'll also talk about the hot topic of PTO, vacation, paid sick time, and how that's changed over the last few years. A little reminder about equal pay for equal work. It's a 2-year-old law. However, they are collecting fines. So we'll talk a little more about how they do that, the agency. We'll talk about non-competes, how the state legislature has tweaked it even further, but it's not that different from the way it's been. There's a new unemployment form that whenever employees are terminated, you have to provide them. So we'll walk through that. We're going to do a little reminder about 1099 workers because the fines from the IRS are so stiff that it's scary to us. So we like to make sure people are paying attention to what constitutes a 1099 worker versus a W-2 employee. Little reminder about some changes in workers' compensation. And we're going to talk about Healthy Family Workplaces Act, public health emergency, and monkeypox. Pretty exciting stuff. And then at the end, a lot of clients have asked me, what do you think some of the trends are? So I did some research out there in the world to see what other companies are doing when it comes to raises in 2023. So let's go ahead and get started. Every year, the Wage and Hour Division updates the minimum wage guidelines for employees. And as you can see in 2022, it was $12.56 for hourly workers. It's gone up to $13.65 outside of Denver, effective January 1st. And then, of course, Denver has its own minimum wage, about $17.29 an hour. I do not see any stop in these increased wages. I think it just has been going for several years. There's also some, stipulations now about final pay. In particular, there's been, and you'll see more about this, a conversation about if someone walks away with company equipment, how do you collect that or the value of that? And the state has some input on that. Talks about permissible deductions. They've narrowed that somewhat. So that you can't take pay out of people's final paychecks without some documentation that's been approved. We'll talk a little bit about commissions and bonuses and how that's being regulated. And then we're going to stand there. So I do want to mention to you that for the Wage Act, there's a new wage theft amendment that was passed in July of 2022, where employees can file a claim on behalf of a class of employees, and the state can investigate for that group. This is really severely limiting an employer's ability to collect attorney's fees while defending themselves. So I'm scared of the Wage and Hour Division in Colorado, or even the federal one, because they are, if they get curious about how businesses run, they're going to ask for just a ton of records, which most businesses don't have organized thoroughly. And typically they find back pay and potential fines if people don't have their act together. So I always say, we got to make sure you follow all the processes. I want to also add that for salaried workers, the minimum wage has gone up to $50,000 this year. And in 2024, minimum wage for salary workers will be $55,000. And I don't know when that's going to stop going up. So what I say to small businesses is plan for increased costs in that area. All right, so family. You probably heard this in the news. It affects all employers with 10 plus employees. And what it means by covering them, it means you have to pay that 0.45% tax. The benefit provides 12 weeks of job protected leave every year for similar reasons to the federal FMLA law, which for family or medical reasons. That benefit actually starts in 2024. And people will be eligible to take the leave after they earn a certain dollar amount, which is also different from the federal FMLA law. And if you don't know about federal FMLA, it's mandated for employers with 50 or more employees, and it allows for 12 weeks of unpaid leave and protection of benefits. The FAMLI is an extension of that, only it offers paid leave. And it's similar to unemployment. And there's even a calculator that can tell employees how much they would make while they're on FAMLI. And then employees have to give you notice. One of the things we're preparing for this year at BBSI is how to put a process together for small businesses so that if an employee comes forward and says, I need to take advantage of FAMLI come January, you are ready for it. The withhold has already begun. So you should, if you have 10 or more employees, you should be seeing a 0.45% tax for the employer side, and all employees in Colorado have to pay the 0.45 tax as well, regardless of company size, for all employees. And again, the benefit begins on 1/1/2024. And what I'm finding and looking at the calculator, I was playing with it to see how much employees actually get. The lower compensated people make a pretty good, percentage of wage. Higher compensated people less so. So I believe there's going to be a lot of use of this next year. And my worry, in particular with FAMLI, is that it will disrupt the businesses. I want to make sure businesses have a backup plan for when employees actually take advantage of this particular new program. And then, of course, there is a family program notice, the poster that's available through the family website that should be posted this year to inform all employees of their rights under this new law. This was not passed by the legislature, by the way. This was voted in by the voters, Colorado voters. There are exceptions. Local governments don't have to participate. Employers with 9 or fewer employees are exempt from paying the employer portion. However, the agency told me that all employees are eligible to access the benefit regardless of company size, which I think is crazy. If you have less than 5 employees, that's very disruptive, but it is what it is. Employers can apply for approval of same or better leave. So what that means is if employers have a paid leave program, short-term disability, that's better than the state plan, they can apply for an exemption. All right. And then, of course, the leave is calculated based on people's pay going backwards 12 months. They will apply for benefits directly to the agency, much like they do with the unemployment division. And they will also notify the employer of the claim and make a determination whether or not that employee will be paid within 2 weeks. So it'll work very similarly to unemployment. We'll see. I mean, it's a brand new agency, so my hope is it'll work very efficiently, but I just don't know. The decisions are appealable, and you can require employees provide you a doctor's note that says they are fit for duty to return to work. What do small businesses have to do? They should be registering with My Family Plus, the website, by 1/1. So of course that was back in November. I would bet you money that many businesses have not done that, but my advice is to get, if you don't have a tax account that's registering your business, make sure you do it. We at BBSI collect and remit the premiums for our clients. Other payroll companies may do the same thing. So check if you have a payroll company. And then handbook policies, I would say that you should update your policies in late 2023 and roll out updated handbooks to explain the policy to employees so they know what to expect. Of course, there are lots of resources. There's the premium and benefits calculator, which I encourage you to play with. There are webinars, and of course, there's the poster that you should be posting. One last thing about family. Healthy Family Workplaces Act is full wage replacement, which means it's if I get 48 hours a year, full pay. Family is only partial. Employers may not require employees, and they should not, I should say they must not, and require employees to use sick, vacation, or PTO while out on family, which is different from the federal law. And the employee could agree, so you can't require it as the employer, but if the employee wants to do that, that's okay. So we're going to move on to the next topic, unless, Dustin, there are some questions out there on the chat.
There are not, but I do want to point out that we will be sharing these links and everything in our email that's going to come later with that survey. So just to keep a heads out or an eye out for that. We're going to have brochures, documents, and all the links that are in this presentation in that email.
Thank you. So 2 things to remind you before we move out of FAMLA. 1, there's a paycheck stuffer that we can provide you that the state created in December. You should distribute that out to all employees. That explains the tax, why they're being taxed in case employees have a lot of questions about it. It explains the law. And number 2, post that poster as soon as you can. All right, so on to Colorado Secure Savings. This is a state-sponsored program, and the impetus for this was Polis made a comment that a lot of younger workers have not thought through what they're going to do for retirement. There's low participation in 401ks or SEP IRAs, in his opinion. His worry was, Social Security may not be solvent by the time they get old. And so, they need a safety net when they get to be older workers. And so this is now a new program. It's kind of started slowly, a little bit 2022. It's still not 100% up, but it's a state-sponsored security retirement savings. If small businesses with 5 or more employees do not offer any kind of retirement program, they are required to sign up for the state-sponsored Colorado Secure Savings. All employers must register with this program and they can opt out. So this shows you the requirements, 5 employees and at least 2 years, and you have no retirement plan. The max contribution is $6,000. You can do they're doing a graduate enrollment because the website was not quite ready for the onslaught. So based on your employee count, if you've got a lot of employees, you got to sign up by March 15th, 15 to 49 by May 15th, and small employers 5 to 14 by June 30th. And that means you get on the website and you sign up. If you do not offer a retirement plan, what will happen is you will have to send the state a census of all your employees plus their contact information. The state will notify your employees they're now eligible for the Secure Savings Program. They'll get letters and snail mail. I actually had a client have this happen to her, and they have to sign up. Now, if an employee does not opt out or respond to the state, the employer will be required to deduct 5% of their wages and deposit it into the Secure Savings Agency, all right? And that's going to be a hard pill to swallow for employees. Some other requirements about this: there are no fees, so it's you don't have to pay anything. However, it is administratively cumbersome. The initial registration, it's not too bad, but any changes like new hires and terms, any payroll deductions is something you have to do, as well as sending funds to the agency. So that administration needs to be done. You can ask for it as an exemption if you already have a retirement plan. And you can also send employees the link for more information. It's a very user-friendly website. I've actually spoken to these people quite a bit as I ask questions about Colorado Secure Savings. They're super nice and fairly well informed. Some other requirements is the employee needs to be 18 years old and be employed at least 180 days or 6 months. The contribution starts at 5% of their pay. It's after tax. There's no required employer contribution, and the employer is not the fiduciary, so they're not liable for employee decisions. So my ask of you is prepare to participate. Tell the employees that it's coming, but don't offer any advice about what to invest in, because you don't want to do that. And if you don't want to do Colorado Secure Savings, or you want to offer something that's better than the market that you can put on your ads, then look into a 401k or a SEP IRA program that's the same or better than the Colorado Secure Savings Program. Might cost a little money, but it might save you an administration headaches. So any questions on that, Dustin? None. I've shocked everybody. I've shocked everybody to silence. All right. All right. So paid time off. So for many years, PTO was a loophole in the state law where if you called it vacation, you had to pay out vacation upon termination. However, PTO, for whatever reason, was not in scope, was not part of that requirement. That changed a year ago, and the state specifically included PTO and said you must pay it upon termination. So the answer is yes, you do. All right. It's earned wages. And in other ways, you have to pay it upon terminations. You don't have to worry about holidays or floating holidays or bereavement. It's just vacation or PTO. And you can't have an agreement to forfeit or vacation or PTO once it's earned by the employee. In other words, if you have in your employee handbook that you use it or lose it, like if I don't use my vacation by the end of the calendar year, you take it away, that is now illegal. So you should remove that language from your handbooks. Now, the other thing to think about with PTO or vacation is if you've had sick time included in that, I'll talk about HFWA sick time in a minute, but think about the cost of having it all inclusive in your PTO plan, because you're required to pay out PTO upon termination. If you separate out the HFWA paid sick time, you don't have to pay that out upon termination. So you may want to separate them out to save money. but we'll talk more about that in a minute. Okay, the next thing we're going to talk about is equal pay for equal work, was enacted 2 years ago. It is a law that nobody really understands, but here's what the impetus for this was. Many younger workers, and I hear this a lot in the university, want pay transparency. If they had their druthers, they want to know what everybody's making, which I think is crazy. But what they're looking for is they're looking for gender discrimination. That's really what's driving this law. So gender discrimination, statistically, according to the Bureau of Labor Statistics, gender discrimination has been endemic in the work world, where women on average made 70 to 80% of what men make. All right. So the Equal Pay for Equal Work Act is trying to resolve that issue. Part 2 of this payment is that you must include a pay range in your job postings. And by the way, Colorado Department of Labor is trolling for fines. In fact, they have fined people for not putting realistic pay ranges on their job postings or putting no pay ranges on their postings. So they are fining the employers for not doing that. You want to make sure, and it's easy for them to do, so make sure that doesn't happen to you. The other thing you have to do is notify employees of promotional opportunities. And the expectation is on you to provide proof. If the Department of Labor calls and says, show me how you're complying, you've got to show them that you have a job posting, and if anyone applied, similar to an affirmative action scenario, if anyone applied, this is who applied, et cetera, et cetera. Employees can file complaints to the division in writing with evidence. Evidence could be that they talked to other employees and found out that the man was making more money than all the women. That's evidence. Remote jobs are also included. So if I am an employer in New York and I have some Colorado employees, I am required to follow the Equal Pay for Equal Work law in Colorado. I'm sure you heard that there was some scuttlebutt about some companies refusing to post jobs in Colorado because of this. That has since, I think that went away. There was a lot of outrage. I think there was potential lawsuits about it, but that has not happened. Record keeping is another big issue where you are required to put a job description in every employee's file. You don't have to show it to them. You just have to keep it in there. And you should make sure that you have in your HR database a report that can show pay, gender, and show the job titles, so that if the Department of Labor calls and says, can you show me your report on your compensation, they can take a look at statistics for themselves to see if there's any kind of gender discrimination going on. All right. There are exceptions, and it has to do with outside of Colorado. So employees that work outside of Colorado are exempt from this. And other than that, I don't see a lot of other exceptions to that. And they do spot check. Now, they haven't spot checked a lot the last 2 years because they haven't had a lot of people in the agency to do this work. So I expect that we'll see more of that, especially if the agency wants an easy way to get some fines. Now, what we mean by spot checking is that the Department of Labor will look at job postings, and if they don't think the pay ranges are real, you get fined. If it says full benefits, that's an issue to them too. It should list what the benefits are in the job ad. Fines could be $500 to $10,000 per violation. The good news is in 2022, there were only 3 violations. One was 8,000 for spot on transact. It was 34,500. And Advanced Circus was 2,000. And they have received about 200 complaints from employees about violations. But I expect this will continue to be a headache for a lot of small businesses, as most people do not know all the requirements of the law, which is why I like to remind people over and over again. The next topic revolves around non-competes.
Audrey, there was
Hey,
a
Audrey.
couple. Yep. Go ahead.
Okay.
Yeah, we got a few questions that rolled in. So going back to PTO, the first one is if we have PTO maxed on accrual, is that now illegal?
No, that's
Okay.
why it's important to put in your handbook that you have a max and that that PTO will stop accruing. You just can't take accrued vacation or PTO away.
Okay, and that probably answers this other question. They said, if we can't do use it or lose it, can we cap the numbers of hours you can carry over from one year to the next?
Yeah, yes, as long as you don't take away. Now, the way some businesses can do that, and think of that several options here. If you want to end up with a zero balance, or you want people to use their PTO or vacation, you can either pay it out to them, anything that's earned, pay it out at the end of the year, whenever you want to. You could force people to take time off. I mean, those are also options that you can do to keep your vacation balances down to a minimum.
Okay.
Right, any other questions?
Yep, and then one other one. They said the only PTO we offer is the sick time required from the emergency health epidemic, where they accrue 0.033 per hour. So do they have to pay that upon termination?
I am assuming, because it all sounds like the Healthy Family Workplaces Act, 0.0033, 1 hour for every 30 hours worked. That is not paid out upon termination.
Perfect.
Okay.
All right, well, I answered everybody's questions. Thank you.
Awesome. All right, so let's look at non-competes. This is a very busy slide. It's highly technical. I'll walk through very briefly, but I encourage you to read the slides. This was effective in August. And the non-competes traditionally have been not enforceable in the state of Colorado. You know, the business lobby has been pushing back pretty hard about this because in other states it's completely legal. So what the state has done is they've added some caveats to what is considered a non-compete, and they've laid out, you know, that you can have a non-compete if they're highly compensated, if there's trade secrets, you know, confidentiality agreements. There's also, you know, a definition of what highly compensated means. So it's very narrowly defined. And so if you want to know more about that, my ask of you is to talk to an attorney who can draft a document that meets all these very narrow requirements. Some of the new notice provisions is either before a new worker accepts an offer of employment or 14 days before the effective date of their restriction or charge in the conditions of employment for current workers. Employers must give notice of the covenant and its terms. And the agreements signed before August 2022 are not affected. And the restrictive covenants for employee non-solicitation agreements are also not affected. But net, you know, you can get deep into this. I advise you to talk to an attorney to make sure it makes sense to you and the employee. And this walks you through some of the restrictive covenants about the threshold amount, the intent behind the law on employees' rights to work in any field, in their field, and that whole idea of non-solicitation. And it does not apply to a covenant to solicit customers governing a person who at the time the covenant is entered into and at the time it is enforced earns an amount of annualized cash compensation greater than 60% of the threshold amount, or $60,750 in 2022. That is a lot of stuff to digest, and you can read further, but it's very technical. Also, non-competes are allowed for sale of a business, repayment of training costs. You can have a clawback provision as well, you know, where you can ask for the money back, and confidentiality provisions. I would encourage you, if you don't have a confidentiality provision in your handbook, to have that there, because that will protect your information from being used. You can actually, that is legal to use. It's far more powerful than a non-compete. Any questions on the non-competes? Okay, we're going to move on to unemployment. So the division decided that they needed more help in receiving information from employees who file for unemployment. So they created this wicked little form. It's a one-pager. And now all employers must provide an exiting employee this separation form to explain why they were terminated. And I'm not a big fan of termination letters because I think it's risky, but in this case, it's required by law. You have to provide dates of employment, year-to-date earnings, earnings for the last week worked, the reason why they were gone, and your employer information. And the agency thinks that what it'll be able to do is process unemployment claims much faster if you provide this to employees, which is crazy to me because if I resign, why would I get a form like this? I don't qualify for unemployment, but it is what it is. All right, any questions on this one? Pretty simple. You should give every terminating employee that form and we'll have it available for you. Okay, Dustin, no questions? All right. Okay, we're going to move on to independent contractors. Much like equal pay, this is a reminder more than anything else that the IRS is out to get you. If you are not sure of your classification for workers being either W-2 or 1099. So the three factors, the three important considerations, the IRS, yes, the IRS again, because it's out to look for these things, and then workers' compensation, because in many cases, if a 1099 worker does not have workers' compensation, that's an issue to attorney generals, as well as potentially a liability for the workers' comp carriers. And there are 1099 workers that go out there and chase dollars through the workers' comp carrier of a business. So you want to be super careful with categorizing people that are either 1099s or W-2s. I actually had a client last year where they did food delivery with the gig workers, and where they all had their own cars and delivered food. We had at least 3 claims, workers' comp claims, of these 1099 workers. And in some states, Pennsylvania being one of them, they agreed that actually that 1099 worker deserved workers' compensation as a W-2 employee, which means that if the IRS was contacted, they would also owe back taxes, which is a huge issue. So how do you know that you're not having inadvertently a W-2 worker when you call them a 1099? It's called the common law test. It's a 20-factor test that the IRS has had around for years. They also have a form called the SS8, where you fill out the SS8, you can submit it to the IRS, or you can self-assess with that. It's got very narrow criteria, like does person have their own business cards? Do they have their own tools? Do they not get into your network? All these little things. Do they have a workstation? That's risky. Do they have a name badge with your company name on it? That's risky. Are they getting day-to-day direction from supervisors? Another problem. So, you just have to periodically educate supervisors on exactly what a W-2 and 1099 worker looks like. And then you have to have fairly robust filing to show proof, because the burden of proof is on you as the customer for this 1099 worker, that they're actually 1099 workers. So here's some reminders, the 2 rules of 2. Okay, the first rule, the worst reason to classify someone as a 1099 is because you want to. There's no other good reason. You just want to. They don't want to pay taxes. You agree. Or someone thinks they're going to save money by doing that. The second rule, these are big red flags to the IRS, is that when you have 2 workers in the same position, and one's a 1099 and the other one's a W-2, big problem. Big problem. That looks like a W-2 employee. And when one person changes from a 1099 to a W-2, or a W-2 to a 1099, and nothing else changes, very risky decision to make. So you want to try to avoid those. I had a few years ago, one employee who was a receptionist that was a 1099 worker. 1 pay period later, she filed a claim with the IRS saying I should be a W-2, and that small business paid $1,700 in taxes and penalties for 1 pay period. This person was making $10 an hour. So just don't mess with this. So what can you do to keep on file? The 20-factor test, the SS8, would be helpful. You should also have a signed contractor, independent contractor agreement that explains in explicit detail, where the liabilities are, who owns the workers' compensation, what they're going to do to pay the tax. I mean, it's got to be very clearly laid out. What happens if someone gets hurt? And then they should submit to you a monthly invoice for payment for services rendered, much like a bill from the grocery store. It's a bill. It's not, they can give you a timesheet, but they're not handing over a timesheet that you use in your payroll account to pay them. They send you an invoice. Those little things really matter. All right. Finally, there's an economic reality test. So current economic realities, the test primarily focuses on the nature and degree of control over work. So that means, is this person supervised day to day on exactly what they're supposed to do on the job? If they are, they should be a W-2. And then the person's engagement in independent business opportunity for profit or loss. What that means is they might have multiple customers they work with in addition to you that they work with. They're not just dedicated just to you as a business, all right? But they're able to make money, and they have to handle their own business quite frankly. And then of course for job training, you should minimize the training you have to provide them. They should come in trained. The more training you do, the more they look like a W-2 employee. And of course the ABC test will have to show that the worker can perform duties that are outside the normal course of the business. They have skills the business doesn't have. I see some chat there. So what are the questions?
Yep. Just one question. So going back to the unemployment section, what are the ramifications if they aren't able to get that separation form signed by former employees?
I have not heard anything yet. This was around since November 11th. I haven't seen anyone get fined. They haven't said anything like that. They just say it's mandatory. I'm thinking that they're doing this for their benefit versus the businesses, but that much like the Department of Labor is famous for doing that. It might be easygoing now because I know this is literally almost impossible to get full compliance for, but I would anticipate eventually they're going to start implementing some fines if employees file a complaint. It's an easy form to fill out. It's not risky to give it to them. And if you terminate them for cause, all you say is terminated. That's it. You don't put why, you just say terminated. But I think the risk is low filling it out. But if you want to do wait and see, you can do that. I just haven't seen anything out there that says bad things will happen to you if you don't give them a form yet.
Perfect. Thanks, Audrey.
You're welcome. Okay, workers' compensation. Well, currently, if an employee is injured on the job, the employee has to notify the employer within 4 days of the occurrence of the on-the-job injury. And if they fail to do so, they could result in reduced compensation for this injury. So that 4 days, that was extended out to 10 days. All right. So that's the big change. And then they have to post this enormous poster. It is like comically huge. I think it's like 27 inches by 40 inches. And you should have that posted. It needs all this information, your employer's information, who's responsible for work comp insurance, says they have rights. It's written in gigantic font. And so if you don't have that poster, you should get one as soon as possible. What we do at BBSI is we've already provided this gigantic poster to our clients. Some of them have put them in the back of the bathroom doors. I mean, that's just, it's so big, you almost have to have a whole wall for it. All right, and then, of course, it's huge. No questions on workers' compensation? Nope, okay. All right, so we're gonna go back to paid sick leave because it's been around a couple years. And just as a reminder that employees, all employees, part-time, full-time, seasonal, all employees are entitled to Healthy Family Workplaces Act paid sick leave, 1 hour for every 30 hours worked, up to 48 hours. You can declare a calendar or anniversary, but 48 hours. That's that 0.0033 that we heard about earlier. They can use the leave as soon as it's accrued for the safety and health related reasons. So after 40 hours, it should have 1 point something hours. They can use it in 1 hour increments. The employer can elect an accrual method. You can decide if you want to give them a lump sum of 48 hours at the beginning of the year or have it accrue for every hour worked. If you do every hour worked, you want to make sure you pay them it accrues with overtime as well. It does not accrue with holiday or vacation, but you should have a system that allows you to accrue for all hours worked for hourly employees. It does not have to be paid out upon termination. I mentioned that earlier. And I am advising my clients who have PTO to break them out because that's 48 hours less that you have to pay. Now, the downside to that is if you have an 80-hour vacation policy, for example, and you take away 48 hours for sick leave, you're now telling your employees they have 32 hours of vacation, which is a hard pill to swallow. So what some clients are doing now is they just say, well, you can use your sick time for anything you want, but if you get sick and you don't have any, you're not going to get paid. But you can include it, paid sick time in your vacation if you want to. It's not forbidden, but it is expensive. All right. Any questions on that?
Still good.
Still good. Okay. All right. The next one is paid healthy family paid health emergency, public health emergency. Public health emergency is a declaration by the Department of Health and Human Services that we are in a COVID emergency. And so all employees are entitled to 80 hours of sick leave in addition to HFWA, which equates to 120 hours for all employees. I would not publish this in too many places because the policy is, or the law is highly restrictive for employers. It's on the poster in fine print. But you know, if somebody wants to work the system, this is one way to do it, and I'll tell you why. The public health emergency has been around since January 1st, 2021. It is still in existence today. It has been extended over and over again by the Department of Health and Human Services, and I honestly don't anticipate an end anytime soon. Okay. On November 11th, in the state of Colorado, they expanded that to flu and RSV, but thankfully they ended that in January, so that doesn't count. And once those employees use up that 80 hours, there's no more that you have to give them. All right. Part-time employees are eligible for PHE leave based on their 2-week average as well. All right. So that is a deep, dark secret that you know now. And it is something you're legally obligated to do. Now, I had an employer say, I refuse to do that. I can't afford it. And so he got a call from the Boulder County Health Services. They called him and they said, if you don't give that employee their 80 hours, we're going to give them free legal service to sue you. Tri-County also did the same thing to another employer. So for whatever reason, the health departments are getting in the middle of this and threatening employers if they don't give these employees the 80 hours. So that's just a heads up for you.
Audrey, question there. Is that 80 hours only for COVID? And if so, can they ask for COVID tests?
Great question. It is only for COVID, and no, you cannot ask for a test. You can't ask for proof. That's why I say it's easy to work the system. This is a insidious regulation that forces employers to put out 80 hours, and I could go, I'm sick, see you in 2 weeks. You just can't ask for a doctor's note or anything like that, or a test. All right. So the reasons you can take that time off is for isolating, which is similar to the old COVID world. COVID, you have to go out for a test. You have to go to vaccination. You don't feel good. You can't work because of the susceptibility or risk of COVID. You need to care for a family member. Those are the reasons that anyone could take COVID leave, COVID sick leave. All right. Any more questions? Okay. All right. Now, monkeypox. We now call it Mpox. That's the appropriate term now. Fortunately, it is not covered under public health emergency leave because it's not life-threatening, but people could take advantage of it if they want to use HFWA. All right. So that is it about the wild world of laws. I usually see steam coming out of people's ears after listening to all that. It is the world of Colorado, and I believe it's going to be more complicated in the years to come. I also think a lot of the younger workers are pushing hard for more regulation on things like equal pay and time off. I am seeing that many companies are trending toward unlimited time off with some stipulations. So that is the one caveat where you don't have to pay out accrued but unused PT or vacation if you have an unlimited leave policy. But I expect that eventually the Department of Labor is going to want to get their claws into that one too. Right now, it is a loophole. So if there are no questions, I'm going to move on to trends. That sound okay?
Looks good.
Okay. All right. So what I did was a lot of research. Luckily for me, I have access to DU's library, and I love the Bureau of Labor Statistics to see what is happening out there in the business world. And you probably have encountered employees coming in and saying the rent is really getting expensive here in Colorado. I need a 30% raise. I have seen a lot of my clients going through 10, 20, 30% raises several times a year, depending on the job. So it's really a problem. So the question is, what's going on? Well, inflation, it's been between 7 and 8.5% in the last year. I think it's gone down a little bit because fuel's gone down. Now it's going back up again. So this is just an ever-changing needle. What we've seen for 2022 is that merit increases have gone on average about 4.6%. Most companies are doing that. We didn't used to have COLA adjustments or cost of living adjustments. We did in the 90s, but it hasn't happened since then. But now you got about 40% of workers asking for raises, and many expect COLA adjustments between 5 and 6%. And then, of course, another thing that's adding some upward pressure is that minimum wage has gone up about 8% in 2023. So, what is an employer to do? Well, you can't just continue to give raises. You just can't afford to do that. So what I'm encouraging employers to do is to look at other options if they can. Also in demand is hybrid or remote work. Every one of my professional college students are pushing for remote work or hybrid work, hybrid being that they work at an office part-time and home part-time. It's a hot issue for younger skilled workers. They also, a lot of workers want flexible hours, where they have a little more flexibility. Bonuses are pretty exciting for people. That seems to draw that they're money driven. But another one that I hear a lot, and I've actually heard this firsthand from employees, is they want more career development. And this is particularly true for millennials and Gen Z workers, where they want to talk about what kind of internal growth there is. The catch to it is that many of these employees only stay 1 to 3 years at best. But what you can do to mitigate the only money request is to have a few more benefits that excite employees and make them want to stay with your organization. And that is enough about the trends. And we got done in about 50 minutes. I do want to highlight, something that Jared had mentioned. We do offer all these services for our clients. We cater primarily to small businesses, and we have just a variety of services. The businesses that I support, I am their HR person, and I know them very well and can proactively figure out where the people issues pop up with them. So it's very much best part of my job is being around those clients. So Dustin, I can advance to the next slide if you like.
Yeah, absolutely. Go ahead, and I appreciate your time, Audrey. That was fantastic. We are actually a client and partner of BBSI's as well. Lakeside is, and Audrey's always on top of it with these new laws and regulations that come into place. So we appreciate it, Audrey, for all you do for us as well. So I'm actually going to toss this section on over to Jake in our office. He is actually the specialist, the expert when it comes to employment practices liability, and I'll toss it over to him.
Thanks, Dustin and Audrey. Really appreciate all the info. It's a lot of stuff going on in the state, and what we learned last week with sitting in the Arvada chamber is that there's more and more regulations that are going to continue to change in the coming years. And so if you're not getting ahead of things right now and being proactive, it's going to be a problem. And we can't be reactive in the world right now with inflation, with supply chain issues, as well as employee shortages. Before I jump into employment practices liability, we actually have one more question, Audrey, if you wouldn't mind providing an answer. So the question is that if someone has 48 hours of sick pay at the end of the year, do they still have to let them accrue more sick time for next year?
No. Much like your PTO and vacation policy, you should have in your system a max option where if they get to 48 hours, they stop accruing. If they use the PTO, the sick time the following year, it can start to accrue, but only up to 48 hours.
Perfect. Thanks, Audrey. Appreciate that. So touching on all the things that Audrey discussed, and something that we always say at Lakeside and we like to explain to our partner clients is that it's not impossible to be in compliance, but it's improbable. With everything that's going on, all the changes that are happening every year, there's no way to always be in full compliance because it's truly improbable. But having partners like Lakeside, like BBSI, or any other HR outsourced people is really important. So employment practices liability plays into this extremely well. So it's an insurance policy that covers the business for any type of issue or employee related problem. So you'll see basic policy versus fully loaded. For those of you that are a client of Lakeside, we've gone through this, you understand that having just a little $100,000 limit is not enough. And as you could hear from Audrey, some of these fines are large, and that's just a fine. That's not even having to go to court. So really, employment practices is protecting business owners from any type of discrimination, wage and hour violation, workplace violence, harassment, anything that you can think of that's going on in the workplace between employees, the employer, or where the third party comes in on the next bullet is if your employees are acting that way to a client of theirs. So having an insurance policy like an employment practices liability policy is a safety net. It's kind of that last line of defense, and having defense costs that can come in when you are litigated against these certain topics and issues is extremely important. Just like here at Lakeside, we use BBSI and utilize them every single day for questions and issues that we're seeing in the marketplace. It's really important to be discussing this with your insurance agent, hopefully Lakeside or your current agent, and really just getting an understanding of what are the procedures we should have in place? When are employees supposed to be signing handbooks? And kind of the slew of things that Audrey went through, it's, hey, when are we supposed to have employees sign those termination forms? Or when are these changes happening? And as Jared touched on earlier, and we like to talk about too, we want our business owners to be operating the business and not be working inside of it and worrying about everything that's going on. But really keeping that revenue stream going is really, really important. So as you guys can tell, a lot of changes that have happened in the last couple of years, and it's only going to continue. So again, really appreciate the time. I know Dustin might have some more words for everyone, but those of you that are Lakeside clients, we really appreciate you coming on the call today. And those of you that aren't, we appreciate that as well. And we're looking forward to the partnership that we have with everyone.
Appreciate it, Jake. Yeah, thanks again, everybody, for joining us. I'm actually kind of shocked we got all that in under an hour. Thank you, Audrey, for pushing through that quickly. I know that was a lot of information, everybody. What I will ask is that if you do have any questions, here's our contact information. We'll be sending that out in that email along with Jared and Audrey's information as well. So that way you can reach out to any of us and ask any question that you might have that either you weren't able to ask on here, or if you're just thinking about it after the fact. So feel free to reach out. We're here to help. Even if you're not a client of Lakeside's, we're definitely here to help out and review anything that you might have. So thanks again, everybody, and hope you guys all have a great rest of the week.
Thank you.
Take care.